Hey folks, Attorney Sharif Silmi, and today we are going to bust a major myth that is out there. And that is that one may not apply for more than one employment-based category at the same time. That is completely and totally false. You may apply for more than one employment-based category even at the same time, so long as you qualify for the classification that you're seeking. For example, if you take the two self-petition classifications under the employment-based system, you have an EB-2 national interest waiver and you have the EB-1A. One may apply for both of those classifications even at the same time. Let me tell you how. Because the EB-2 national interest waiver requires that you have an advanced degree or 5 years of qualifying experience or extraordinary ability, and that you have a proposed endeavor that's beneficial to the U.S., that you are well positioned to advance the proposed endeavor, and that you pass a balance test. The EB-1A has actually pretty similar requirements. It is that you have already achieved sustained acclaim that is recognized in your field. So with the EB-1A, you've already achieved sustained acclaim. Well, if you've already achieved sustained acclaim, certainly you are well positioned to advance your proposed endeavor. So those things go hand in hand. And perhaps if you are well positioned to advance your proposed endeavor, it is because you have already achieved sustained acclaim. So there is a possibility and even a likelihood that one who qualifies for one of those self-petition criteria, that is the national interest waiver, can also qualify for the EB-1A or vice versa. So the question becomes, can you apply for both? The answer is absolutely yes, you can. Because if you are able to apply for both the EB-2 category and the EB-1 category at the same time, you are absolutely free to do so under the statutory law. In fact, sometimes one may apply for a national interest waiver to lock in a priority date, and subsequent to that, they would complete the path that they're on and apply for an EB-1A. So there's no truth whatsoever to the idea or the concept that one's national interest waiver would somehow interfere with their ability to file for an EB-1A. In fact, I would view national interest waiver as a part of the same path towards an EB-1A. That is to say, if EB-1A is the end goal, then a national interest waiver might be ready to be filed somewhere along that pathway. So before you get to the point where you feel that you're ready to apply for an EB-1A, you may already be eligible for a national interest waiver, and it could be a great benefit to you. For example, you won't be reliant on your employer in a time where we're seeing many layoffs. You may be in a situation where you're seeking to maybe take a break from employment, right? And you want to have that I-140 EB-2 with you. And subsequent to that, you would be eligible for an EB-1A, and you can file for your EB-1A. There's absolutely no contradiction between an EB-2 national interest waiver and an EB-1A extraordinary ability. Both can live side by side. You can file them at the same time. You can file them after one another. Whatever benefits your individual situation is how you want to approach that. So I would strongly advise you reach out and have your case assessed. All of the above solutions to make your situation better and to ultimately seek a green card and an end to any worries that you might have over immigration. I hope this was helpful.